Okay, well, here we are at chapter 44, which is consumer law. We're rapidly getting close to the end of the course. We have maybe half a dozen chapters left to go or so. Maybe one more, maybe a baker's half dozen if there is such a thing. But this unit is one of those units that kind of stands alone. It has a few surprises in it. I think a few things that are of interest to a student of business law. So let's go ahead and jump in and take a look at Consumer Law 15th edition. Okay, the first thing, and this is really not in your text, but I thought it was important, is to be aware that consumer law actually has a longer history than you might think. Prior to the beginning of the 20th century, we basically were in an age of unbridled regulation. So this led to some excesses in the marketplace. Probably the most famous places we saw these was with a series of scandals that rocked the United States with meat consumption. And the reporters on this, the people that were interested, were called muckrakers. And I mention them because they really did a lot of investigations of the Chicago stockyards, and they led really to the first federal legislation that you can easily point to that was directly designed to protect the consumer. Prior to this, the traditional marketplace used the old Latin term caveat emptor, which roughly translates as let the buyer beware, or you get what you pay for. And I think this is a defensible position when you're dealing with a market where the consumer of the good and the producer of the good are very likely to know each other, to have a relationship. But and in the 1800s, if you were going to buy meat, you bought it from the farmer or the butcher next door. But by the early 20th century, if you're going to buy meat in a can, it might have been manufactured in another state. It might have been slaughtered in a third state. The beef might have come from a fourth state. So there was less and less direct connection, less way for really the consumer to be aware of what he got. Therefore, we began to see the necessity for some neutral third party to protect the consumer. And gradually began to see quite a bit of legislation in this area. And a lot of it is focusing on how things are advertised, how things are marketed, how things are sold. So a big chunk of this here is really federal rules, federal laws against deceptive advertising. And at the core of this is the Federal Trade Commission, the FTC, which was formed. It's really one of the first true administrative agencies in the United States, which we had talked about those previously. It was formed in 1914, and the FTC really supervises and penalizes people who engage in this sort of deceptive advertising. So a deceptive advertising has a very broad definition. What would a reasonable consumer, reasonable person in the marketplace of average intelligence and average knowledge, would whatever you are telling them mislead them? Now, one of the things is it's perfectly okay to provide vague generalities. It's perfectly okay to say this is a great little car, whatever that means, or this is the sweetest deal on the planet. Well, that's what's called in the law puffing or puffery. That's acceptable. What we don't want is if you present something as factual, like this toothpaste prevents all cavities, and it turns out to be false, that it doesn't do it at all. Nor to simply present half-truths like this toothpaste prevents all cavities, but it'll make your gums rot and fall out too. So you're not allowed to lie nor omit something that would lead to a misconception. Another thing you're not allowed to do, and this is a little bit more sophisticated, is bait and switch. That is, advertise a cheap good in order for a consumer to come to your store, not have that good ever available, and then try to get the consumer to buy a more expensive good. That's not allowed. That's deceptive advertising. Now, all ads, newspaper ads, TV ads, internet ads, all of them must be truthful. And you have to have substantial or substantiated evidence for any claim you make. And you can't cause any injury by taking the thing that doesn't provide a greater benefit. Now, let's suppose you take a pill that cures the gout, but it gives you a headache. Well, that's certainly okay because it's better to get rid of the gout than to have a headache. Vice versa, if I've got a pill that will cure a headache but will give you the gout, that would be deceptive to sell that. You have to disclose all the limitations and qualifications. That's why when you watch these drug commercials on TV, they have to tell you all sorts of things like, here's how it can injure you and here are the nature of the side effects. And these disclosures have to be clear and conspicuous in order not to run afoul of deceptive advertising laws. So getting back to the Federal Trade Commission, this is an administrative agency, federally constructed, and what it does is it investigates and determines if any ad or advertisement is unfair or deceptive, and then usually what it will do is it will issue a formal complaint to the offender. 99 times out of 100 what happens is they get a settlement. So the FTC comes and says, well, we don't like the language you're using here about gas mileage on your car. So the automobile dealership says, okay, well, how about if I change it to this? And they might say, that's not good enough. How about a little closer to this? And they negotiate back and forth. If they can't, the FTC can go further. It can issue a cease and desist order, first of all. It can say, stop all advertising until we sort this out. It can, in extreme cases, mandate counter-advertising. You advertised your goods as safe for children. We want you to advertise that it's not safe for children. It's never been tested. It can cover multiple products, not just a single product in a product line. They can seek damage. And the big thing they're going to seek is they're going to try to get all the money that was produced from the product. So if you were selling bubblegum that turned out to be tainted and caused people's teeth to rot and fall out, you would get all the money from the from the consumers who bought those. So you want to get all the profit. So no one makes any money on this. You can also seek restitution, return of money, and of course damages is available. Some of the federal and state laws that are involved here. The federal law, of course, there is the Lamb Act. Lamb Act protects trademarks. So one of the things you can't do is you can't use other people's trademarks as part of deceptive or injury. And then each state has its own laws about deceptive and unfair acts. Remembering, of course, that you retain, if you're injured by a product, the right to sue, not just to sue for the deceptive advertising. In 1991, we have the Telephone Consumer Protection Act, which bans solicitation by automatic dialing. And one of the questions I get is, well, wait a minute, I get this all the time. Well, a lot of the time you're getting that from a number outside the United States where the FTC can't reach to get you. Or there are exceptions for some smaller firms and for all political ads. So all those crazy ads we got in the last election, all those are exempt. It also bans unwanted faxes, and that should show you how technology changes. I don't know if people use faxes much anymore. We also have certain mandated sales disclosure under the Telemarketing Consumer Fraud and Abuse Prevention Act of 1994. Many federal and state laws require you, as I said, to tell you certain things. A big thing they're talking, let's getting back to business here, is what's the actual cost? In particular, because very often it's an extension of credit, we want to know how much money you are lending and what is the rate of interest, the APR, the annual percentage rate. We also want to give people cooling off periods, particularly for door-to-door sales. It's usually 3 days. We want to give controls about if you order something either online now or if you order them by phone, how fast they have to ship. And if they don't ship, how fast they have to refund money. This is federally mandated. This is one of the reasons that Amazon is perhaps not as generous as you think, because they actually have to do quite a bit of this. If they didn't, they'd run afoul of state law, state and federal law. Labeling and packaging laws are very important. Labeling and packaging, of course, according to federal law, labels should be accurate, easy to read and understand, contain no exaggerated claims, specify the contents and the amount of materials. Now, if you get, any TV dinner and you look at it, it's going to give you a breakdown nutritionally of what's in there. It's going to tell you how much this weighs, what the calories are. That's what we're talking about here. And you should be able to look at that and pretty much figure it out. Now, you might think it's silly. It might say in a pack of Oreos there are, I don't know how many Oreos are in a pack of Oreos. Let's suppose there's 25. It might say there are 25 servings. Well, no one on the planet eats one cookie as a serving. But so long as they define it clearly, you're all right. You have to put health warnings on certain products. The most famous example here is tobacco products, that they cause cancer. You have to give warnings or give meanings to specific words, such as what low fat means and what fresh means, how long you have to put something on until it's no longer fresh, whether low fat, what it means. And it generally means in comparison to a fully or a regular serving of that good. So, low fat cream cheese still has a lot of fat in it compared to yogurt. Some of the federal statutes that control labeling, we've got the Wool Products Labeling Act, which was passed in '39, which, believe it or not, the wool industry liked because they were competing against synthetics. Fur Product Labeling Act of '51, this was really before PETA. This is something that's largely disappearing from our society, people wearing animal furs. But prior to that, they wanted an accurate label. Flammable Fabrics Act of '53, so we knew what was and wasn't combustible. Fair Packaging and Label Act of '66, Smokeless Tobacco Health Act of '86, and Energy and Policy Conservation Act, one of the more recent one, which mandates that we show the actual fuel economy of cars. It tells what it is. Now, of course, again, you're allowed some wiggle room. I've never bought a car that said, this gets 60 miles to a gallon, and it got 60 miles to a gallon. Usually it's a little bit lower, which is okay. They're going to give you some wiggle room in all of these. You don't have to be perfect. About the food labeling, because this is something we see all the time, this mainly is under the Fair Packaging and Labeling Act. What's being sold, what's the weight, how many servings, who made it, where it is. This is important too if there turns out to be a spoilage or a problem, so we can trace them back. There's also nutritional labels under the Nutritional Labeling and Education Act. How many calories, what percentage cholesterol, how much salt, how much carbohydrates. One of the things, probably the most recent one under this, is the Affordable Care Act mandated that restaurants over a certain size, so the big chains, McDonald's, Subways, have to tell you what their calorie count is on the foods. Which is frightening sometimes when you see it. Federal Food, Drug, Cosmetic Act protects against all those fields, which is adulterated, misbranded, or contaminated. This is not monitored by the FTC, the Federal Trade. This is under the Food and Drug Administration, the FDA. And they also, along with drugs and cosmetics and food, believe it or not, they also regulate medical devices. So it can be something outside the body, like a wheelchair or a crutch, or it could be something inside the body, like a heart valve. All those are regulated by the Food and Drug Administration. Consumer Product Safety Act was the last big piece that was put in place. This came about, I believe, under the Obama administration first, and the first head of Consumer Product Safety is... Oh no, I'm sorry, I got the wrong one here. My apologies. But the Consumer Product Safety Commission sets standards. It bans the manufacture of unreasonably risky goods. It removes those products and administers legislation. It requires distributors to notify the Consumer Product Safety Commission of any serious defects that cause death or injury. The ACA has multiple requirements. No denial of coverage for previous condition, end of lifetime caps on insurance, mandated that 85% of the money from a premium is spent on benefits or quality control, so no longer just profit. And a big one, which really made sure a lot of people remain covered, was that children up to age 26 can remain or will remain under the coverage of their parents' policies. So this is the new one, excuse me, the Consumer Product Safety Commission. It is founded, I'm sorry, I messed up there. It's founded under the Obama administration, and I believe the first commissioner, if I'm not mistaken, was she's now the senator from Massachusetts, Elizabeth Warren. This was fought tooth and nail by industry because, of course, industry doesn't like regulation. Industry feels that they are freer, able to sell more products, do better. Um, and very often what it does is it takes a crisis or a problem for a new agency or new laws to be put in place. Credit protection. This goes back ways. We have truth in lending, which requires credit and credit card industries to make full and accurate disclosures of what they're doing, and it covers almost all loans made under $25,000, so any sort of small advance. The big thing again, what your APR is, what your finance charge, how much you're financing, what's your total. Now not under necessarily this, more under different regulations for like homeowners, but you probably have seen what's called the HUD-1 statement, which has in black and white, you think you're borrowing $25,000 or $200,000 to buy your house. They're going to tell you you're borrowing. No, you're not getting that much. You're actually borrowing 196 because you're taking 2 points. Okay, you think you're getting it for 3%, but when we calculate it based on that, you're actually getting it for 3.2 or 3.4% or whatever number it is. So they got to give you the real numbers there. They also tell you how much you're going to pay over the life of the loan and how long it takes and what fees you're going to pay, which is real important because traditionally businesses, banks, and credit institutions would hide fees. Was very, very common. Equal credit opportunity bans discrimination based upon a person's race, their religion, their nationality, what gender they are, how old they are, beyond the age of majority, marital status, if they are receiving any government assistance, such as Social Security. It also, interestingly enough, it bans mandatory co-signers. If someone is already qualified, you can't say, well, I want your husband to sign, I want your wife to sign, or I want your parents to sign, if someone's already qualified. Some credit card rules to pay attention to, and this impacts us as consumers. The big thing is limited liability. Basically, if anybody uses your credit card, your maximum liability, if you have liability at all, and I would argue you don't in most cases, is $50. Because after all, what's supposed to happen with your credit card? Well, you're supposed to check the signature on the card against the signature that is given on the receipt. And if they don't match, if they're suspicious or they're not given, then the sale should not have to go through. Well, we've basically stopped doing that. So most of the time if someone fights a credit card, they say, well, I don't want to be responsible even for this first $50. Credit card companies waive it. It mandates certain dispute resolution procedures, and in 2010 we had some amendments passed about this. More disclosures, limited the right to raise the rates on these cards, limited fees on credit cards for over the limit, and it mandated that the rates be applied fairly. Another big thing that's very important to consumers is something I recommend. We'll talk about this in more detail. We start talking about fair credit reporting. Prior to about 1990, 1989, I think, your credit score was not that important a number. People didn't think about it too much. Now people live and die by their credit score. So when we talk about the Fair Credit Reporting Act, your credit score is so vital to get credit cards, to get mortgages, to get car loans, that you need to see what's in that credit report. And if you're one of the industries that collects this data information, you're only supposed to show it to legitimate users. And a full disclosure has to be given of who, what, how, anything got in the report. And there has to be a procedure by that company how the person, if he sees an error, can get it fixed. There has to be a way, a mechanism to do that, because traditionally it was extremely difficult. So I usually recommend to clients that at least once a year you get a copy of your credit report, and it's very tedious. It's a lot of numbers, if you print it out, a lot of pages, but if you're just doing it online, it's very tedious. Go through it and make sure there's no errors, because it can happen that there's someone with a similar name, or they miskey, one letter, and you wind up with something wrong in your report. Most credit reports will have at least a very minor error, and many, most over lifetime, will have major errors. We have the Fair and Accurate Credit Transaction Act, which was passed really to fight identity theft, which set up a national fraud alert system, which mandates, and this is one of the things why my clients can do this, is everybody should get a free copy of their credit report every 12 months. And we limit the content of receipts that you get, both online and in stores, to protect consumer privacy. That's why if you look at your receipt and you have a 16-digit number, you're only going to see the last 4 digits because you're supposed to protect consumer privacy. Now here's a big one that gets quite a bit of play among students, and I'll tell you a quick story about it. The Fair Debt Collection Act, Practices Act, limits how debt can be collected. So here's some of the things you cannot do. You can't contact a debtor at the place of their employment, so you can't call them on their job. You can't contact them at a later than usual hour. If they hired an attorney and you know they have an attorney, that's it. You're not supposed to hire them. You can't contact a third party. You can't call their mother. You can't call their boss. You can't harass, intimidate, or use false or misleading information. Now, stick a pin in that one. I'll tell you a story in 1 second. And you can't contact the debtor after he refuses to pay except to give notice you're going to sue him. Okay, so let me tell you a story that happened here in Raleigh. A woman gets a phone call. Are you Jane Smith? Yes, I am. Is your husband John Smith? Yes, he is. Do you have 2 children, Dick and Jane? I do. Well, this is Rex Hospital. There's been an automobile accident. Your husband went to the school, took Dick and Jane out, and we need to get down here right away. So she gets in the car. She drives like a bat out of hell, 100 miles to the hospital. She gets there. Who's waiting for her in the emergency room? Not a doctor, but a bill collector who says, now, your husband really wasn't in an accident, but you have a hospital bill. You have a medical bill outstanding, and if you don't pay that, they might not have gotten this treatment. When can we expect payment? That's a pretty outrageous behavior. That is using false and misleading information. She actually suffered, I wouldn't call it a nervous breakdown, she suffered a mental event because of this. She became excessively concerned about the safety of her children. She went and saw a psychologist for a while. She went on some medication to deal with the trauma of this. It really shook her up. And of course, we were contracted by her to represent. When we went to the debt collection company, they had no idea that their guy had gone this far, and as soon as he went that far, that was the end of it. And of course, we actually got damages. We got actual damages, her psychiatric bills, her pain and suffering. We got additional damages, and our attorney fees were covered. So this is a pretty strong piece of legislation. It really hopefully prevents a lot of problems. Okay, garnishment. When I first started teaching this was not all that common. I saw it really in 2 places. The 2 times I would see it nearly constantly in North Carolina, I would see it down in Bragg, Lejeune, Pope for child support orders. It was very, very common that a serviceman's wages would be garnished to pay child support. And that's still a fairly common garnishment. It's not unusual. The other garnishment you'll see is for taxes. So you'll see that the government has sued to collect money and they're trying to get it. So private creditors had not traditionally used this a lot, but that has really changed in the last 5 or 10 years. One of the things creditors realized is we can sue people in small claims. We can sue people in district court. Now, it depends what state we're in, obviously. Very often these people won't show up. If they won't show up, we will get an order of garnishment. And before these people know it, we'll be getting a percentage of their money. Even if they had gone to court and argued, the judge would have said, no, you don't owe them this money. But since they didn't show up, we'll get a default judgment. Now, some states ban this except for child support and taxes. North Carolina is fairly liberal in allowing it. the typical legal maximum you can take in garnishment is 25%. It is, as I said, becoming a much more common tool for collection than it used to be in the past. And I think this will probably continue absent new legislation. All right, last thing to really talk about in this unit is state consumer protection. Some states traditionally have a uniform have more protection. Now, you do have the protection of UCC, the Uniform Commercial Code, but some states have adopted the UCCC. So we put an extra C on that UCC. It's Uniform Consumer Credit Code. Now, this is protecting credit purchases in a lot of cases. This is one of those uniform body of codes that has been suggested, composed by lawyers trying to get a uniform body across the United States. Many, many states have refused to do this. Most states do have, and North Carolina does, laws about deceptive trade practice. But there are what I would call consumer friendly and consumer hostile states. Those states that are consumer friendly tend to have a lot of laws in the book. They're going to protect the buyers. Then you have ones that are consumer hostile. They have no laws or very vague laws or very old laws. I would tend to put North Carolina in that. If you looked at North Carolina's lemon law in regards to automobiles, it's kind of a good example. It's pretty weak. You have to jump through a lot of hoops and be in a lot of unique positions before the North Carolina lemon law on automobiles really is going to be useful to you. There are going to be some cases. It's something that lawyers look at when there's an automobile purchase and someone gets a lemon, but very often no. Now, other states, different story, which is why sometimes lawyers want to what's called forum shop. We want to go out and we don't want to have this case in this state because it's unfriendly to us. We want to have it in this state because the laws are better. Sometimes you can do that because the parties are in different states. So the buyer might be located in Mississippi, you might be located in Alabama. Or it might be a multinational corporation, or you might be able to get into federal court depending on how much money you're talking about. But again, you can go to state consumer protection. Not terribly useful in North Carolina. Okay, that brings us in pretty close to half an hour, and that's going to conclude chapter 44. And when you're ready, click on 45, and I'll talk to you then.